is interesting in that we have a request for declaration of pecuniary interest or conflict of interest, and immediately following that we have our integrity commissioner who will tell us what the important characteristics are of the code of conduct and MCIA. So I will first ask if there are any declarations of pecuniary interest. And I'm not seeing any hands raised. So next on the agenda is I would like to welcome our Integrity Commissioner, Suzanne Craig, for a deputation. And she is going to walk us through some of our responsibilities as committee members and perhaps give us some examples of scenarios that we may encounter that may help us to better understand things. So welcome, Suzanne, and if I could turn the floor over to you.
So good morning, Chair Hazelton and members of council, appointed members and elected members of council to the committee. It's a pleasure to be here today. I've met some of you. I know some of you I have not met, and this is a real treat because I come before you, not because I have a code complaint, but for a matter of education, and that is rare in the work that I do. I am appointed Integrity Commissioner to several municipal councils and school boards, and including the District of Muskoka. And in January 2023, I was part of a group of experts who delivered the new council orientation for the Joint District Council of the Muskoka Council members orientation. At that time, there were some questions that were posed regarding how the conflict of interest rules contained in the code and the Municipal Conflict of Interest Act are applied to day-to-day situations of members. A couple of scenarios were given to me. And as a follow-up to those questions, and with a view to providing some clarity, because that's what my role is about. My role is not about dinging people and catching them in wrongdoing. My role is about assisting you in understanding your roles and responsibilities. And so I drafted a Q&A follow-up memorandum. I've included that memo along with the code of conduct for the Township of Georgian Bay and the PowerPoint slides and some scenarios in your package. Speaking of technical difficulties, I am not so savvy, so I have asked Sydney to kindly move the slides forward while I look at my speaking notes, because some of you who know me know that I can rattle on for quite some time. So I'm going to try to stick to my speaking notes. And I have quite a bit to go through today. I thank you, Chair Hazelton, for allowing me the time to speak to your members. I'm going to take about an hour. That's what I've planned. I hope I won't take more, but you can shut off the mic if I go long in the tooth. I prefer questions at the end because I have a quite long list of things that I've tried to include in these slides. But through the chair, if there's a matter of particular clarity, Councillor Hazelton, that you feel needs a pause in my presentation, I'm happy to take the questions. I may not answer it until the end of the presentation. Of course, there's always the opportunity for follow-up memo after this presentation. So without further ado, I'll go on to slide 2, the outline of today. In today's session, I'm going to go through high level, some issues that have been surfacing in many municipalities that I support. And I hope if the questions haven't already arisen around some of the rules that apply to your work circumstances as planning advisory committee members, that today's session and what I cover will assist you in clarifying some of the questions that may arise at a later date. I hope to cover the purpose of codes of conduct, your responsibilities under the code, the rules most important of the Municipal Conflict of Interest Act. I refer to it as the MCIA. I'm going to try to shed some light on the difference between pecuniary, so financial, and non-pecuniary conflicts. And I will conclude with some scenarios that I have pulled from my repertoire of code complaints. that do not relate to your municipality, but there are similarities because, as I said, I see for all of the municipalities in the district of Muskoka. And those scenarios are what I call the rules in action. So hopefully looking at these scenarios, code complaints that I have dealt with will assist you in understanding the substance of what we're going to go through right now. So slide 3, please. What's a code of conduct's purpose? Why do we have them? I could spend a day just talking to you about why we have them. And many individuals and justices who are much smarter than me and much more able to articulate why we have codes actually said so in their reports and recommendations. Justice Denise Bellamy, her findings and recommendations at the conclusion of the MFP inquiry at the City of Toronto, stated that the City of Toronto Act, which was created, and the Municipal Act, should include an integrity commissioner to look at the ethical responsibilities of members of council and appointed members. In 2011, Justice Cunningham conducted the Mississauga inquiry, which looked into allegations of former Mayor Hazel McCallion, who voted in 2007 at the Peel Region Council on decisions about development charges that could have saved her son's company $11 million. This, as Justice Cunningham pointed out in his report, was a conflict of interest issue. But more importantly, it set the stage for a renewed call for the role of all municipalities to have an ethics officer to whom members of council and appointed members of committees could go and receive advice on matters of conflicts of interest and good governance generally. Justice Cunningham said in the Mississauga judicial inquiry, and I'm quoting from his statements, optics are important. It's essential to consider how a reasonable person, not any person, but there is a standard for a reasonable person, would view the actions of the municipal councillor or appointee. He refers in his recommendations to Commissioner Oliphant's comments in the Oliphant 2010 report, in which Commissioner Oliphant said, public office holders, not just elected officials, ultimately owe their position to the public collectively, not to themselves or special interest groups. They owe their position and their allegiances to the municipality and its ratepayers on behalf of whose business they are conducting. He goes on to say, ensuring they do not prefer their private interests or those of select groups of interests at the expense of their broad public duties is a fundamental objective of ethics standards in municipal government, end of quote. As a result of public inquiries on conflicts of interest, there has been a general trend in municipal government over the last 15 plus years, at least as long as I've been working as an integrity commissioner, to develop rules around ethical conduct of what you do, to ensure that you carry out your official duties, the reason why you have been appointed, in a quality of service for all of the municipality and its residents, recognizing there's a greater expectation now than in the past of accountability to the public, as well as a greater scrutiny for what you do. So these higher standards of conduct expected by the public are usually embodied in the Code of Conduct. They are also embodied throughout the Municipal Act, governance rules, other procedures of your municipality. And I will be quoting over and over throughout this presentation, the Municipal Conflict of Interest Act. The code rests on key principles that you should keep present in all of the work that you do. And listen, I know that I can sound preachy, and I apologize for that, but if I'm going to communicate what the rules state, I have to take that tone. So for those of you who don't know me, my goal is to help you understand your role, not to admonish you. So what are the key principles of the Code of Conduct? Well, there are standards of codes of conduct which are held and you accept when you sign on as an appointee. And the Code of Conduct contains these standards which are extrapolated from the Municipal Act and the Municipal Conflict of Interest Act. Another key principle of the code is, as an appointee, you're required, as part of your appointment, to remain in good standing as an appointee, to fulfill your duties with honesty, reasonable care in identifying personal conflicts of interest, and to be fair in the treatment of all the matters that come before you. And finally, the key principle of understanding the perception of optics. Government is transparent in what you do. You all live in the community and people know you. And so it's important that you act in a way that is also perceived using the reasonable person standard to be without an appearance of conflict to enhance the public confidence in local government and the reputation of the township. Next slide, please. So what are the guiding principles and what do they say about your day-to-day? Members of public appointed committees are appointed at the pleasure of council. Some of you are council members, some of you are citizen appointees. Appointees do not hold office, nor do they represent the constituency within the community. Members of the public appointed to committees must respect both the word and spirit of the code as it applies to them. Committees operate, and I'm sure you know this, only within meetings for which proper notice has been given pursuant to a set agenda, unless otherwise mandated by council. It can be a special meeting. These rules for committee are in place so that the committee doesn't become, and often people say, a shadow council, attempting to put forward in recommendations to council an agenda not approved by council as the mandate of the committee. Next slide, please. No committee member may act beyond the mandate of the committee granted by council. You must not undertake independent site visits, direct discussions with residents or staff, hold informal meetings or communications, including emails about matters germane to the committee, except as granted by council through the terms of reference, pursuant to a resolution of the committee, or otherwise as required by law. So it's set out in the Planning Act or some other piece of legislation that you're working with. Members should not have predetermined positions on a matter. So that doesn't mean that you can't have an opinion or your perspective. Of course you can. Your experience is what brought you to this appointment. However, you leave your positions open to reasonable persuasion, and your interests while deliberating and deciding on advising council are those of the entire municipality and not specific interest groups. Next slide, please, Sydney. Slide 6 to 9 show the relevant code rules pertaining to the work you do. I'm hoping that you've all taken a look at the Code of Conduct, but if you haven't, I invite you to take a look at that document. There've been a couple of iterations since I've been Integrity Commissioner, and I know that your council has worked diligently to ensure that the code covers the expectations of council and its appointees. So slide 6 looks at the general principles of the code rules that apply to you and definitions. So conflict of interest in your code states a situation in which a member has competing interests or loyalties between their personal or private interests and their public interests. You can take a look at the rest of slide 6 on your own. Going on to slide 7, please. Non-pecuniary interest, which is this nebulous, nowhere defined except in many court cases, but you have set in your code just to give some clarity and some guidance, is a private or personal interest that you, member, may have that is non-financial, it could be non-financial, and that a reasonable person, there we go again with that reasonable person standard, apprised of all the circumstances, may believe that this is likely to influence your decision and may include an interest that arises from a relationship with a person or an entity. Knowing a person casually through work generally does not create a conflict that carries a disqualification or a pecuniary interest under the MCIA or a bias under the code. However, a business owner, for example, a contractor, a real estate agent, may always have some interest in matters such as rezoning, subdivisions, etc., because of the potential for increased activity in the gaining of clients or real estate sales. But it is the relationship between a member and a property or a situation, a category of business or an individual that takes the matter beyond the potential for future business into the realm of private advantage. And I'll talk more about that a little later. Slide 8, please. Slide 8 sets out the rules that require that members and appointees do not disclose what is discussed in closed session or otherwise confidential and to not use information received under confidential cover for private or personal gain. Slide 9 discusses conflicts of interest, and I'm just going to read that code conflicts, which is a member shall not use the influence of their office or appointment for any purpose other than the exercise of their official duties. What are your official duties as a planning advisory committee member? You should have terms of reference of what those duties are. And if you don't, you should work as a committee to establish those, because the code says you can't use your official position for anything outside of official duties. So it's important that that's clarified. The code goes on to say, as a code conflict, members shall not use the status of their position to influence the decision of another person to the private advantage or non-pecuniary interest of themselves, their parents, their grandchildren, spouse. So people you know, not just casually, you can't use your status, what you know, your influence on your planning committee to benefit them or to the disadvantage of someone else. Looking at the slide on conflicts of interest under the MCIA, in slide, I think that's slide 10, members shall avoid conflicts of interest, both pecuniary and non-pecuniary. I mean, you do that before every meeting. There is a statement. Are there any declarations of pecuniary interest? You should look at the package before you attend a meeting, because your requirement is to declare that pecuniary interest before the meeting starts. At the meeting, you make a public disclosure, and then you leave. And so it's really important to do that due diligence to make sure that you don't have a pecuniary interest. But again, the Act does talk about known to the member. So buried in the package may be something that you didn't know about, and so there's always the option afterwards to say, you know what, I had a pecuniary interest, but we prefer that not happen, and that's what I'm here for. I'm here to be able to provide you advice on whether or not you may have a pecuniary interest. Slide 11, please. So the purpose of the MCIA is not to make your life difficult. I agree that it's a pretty, the term that's been used is draconian. It's just been sitting around for decades. And it's a tough act to amend, and so it is what it is. But the purpose is to ensure that an elected or appointed official does not derive personal or private gain from being in elected or appointed office. You can't use that sort of like for insider trading. While working on the Planning Advisory Committee, your focus is on the best interests of the municipality, with advice of staff and input from other experts and your community members. You may have a different perspective than some of your colleagues. You may have a different perspective than some of the community members, but this is quite different from having an entrenched position or a personal, private, financial agenda. A City of Toronto councillor who was investigated a while back wanted to institute bike lanes. That's fine. They may have campaigned on bike lanes. However, the staff report that came forward set out that it had to be phased in. It had to take a phased in approach. And there were infrastructure challenges that had to be addressed before they could look into the development of bike lanes. There had to be transportation studies, et cetera, and they had to look at the budget line item. So the advice of the Transportation Accessibility Advisory Committee, on which this member participated, had to give recommendations that were in the mandate of the committee. So even though there may be a belief that a particular project or idea may be beneficial to many of the residents of your municipality, you have terms of reference within which you must operate, which stems from the mandate of your committee, and you work for council in the best interests of your community. Slide 12, please. So this case, 1979 case, still resonates. Many people still use it. Just because something's older doesn't mean it's not still valid, and courts still use this case. The purpose of the Act is to prohibit members of council and committees from engaging in the decision-making process in respect of matters in which they have a personal economic interest. There's no need to find corruption on his or her part or actual loss on the part of council or committee. As long as the member fails to honor the standard of conduct set out in the Municipal Conflict of Interest Act, then he or she is in contravention of the Act, regardless of good faith or impropriety of motive. This is what the court said. Often members will say, well, this will generate income in the community to help with the rising expenses of the municipality. We need these development charges because otherwise we'll have to tax, et cetera, et cetera. While stewardship is a governance cornerstone of the municipality, the purpose of the municipality, generally speaking, under the Municipal Act, is not first and foremost financial. It is not a financial endeavor. And as set out in the Municipal Act, the municipality is created to provide services which the municipality must provide, including social and environmental well-being of the municipality and its residents, and advice to council must be within this focus. Consideration of making money, absolutely not the focus. Important to note that in addition to the MCA rules for pecuniary interests, the Code of Conduct broadens the sphere of conflicts to include private advantage, common law conflicts. So there are MCIA conflicts, which are prescribed and limited about a pecuniary interest. And then there are broader considerations of conflicts which are found in common law. They include social, personal, and those conflicts that lead to a private advantage. And they're usually covered in the Code of Conduct under use of influence or improper use of influence in the code. That's usually the heading. In the Mississauga Judicial Inquiry, Justice Cunningham stated, and I quote, "Members are not to use their position to promote private interests, whether their own or those of relatives or friends or associates. They must be unbiased in their exercise of their duties. That is not only the common law," he states, "but the common sense standard by which the conduct of municipal representatives ought to be judged." Slide 13, please. So what is a conflict of interest? I guess you wouldn't need an integrity commissioner and a bunch of your own lawyers if we could just figure this out. But for the time being, it depends. Pecuniary interest is not defined under the MCIA. Jurisprudence has established that a pecuniary interest under the MCIA is a financial, monetary, or economic direct or indirect interest of the member, not hypothetical in future, but present. Under Section 3 of the Act, a direct or indirect pecuniary interest of a spouse, child, or parent, if known to the member, is deemed to be the member's own interest. To understand this, we often cite a lesser-known case, Mondu versus Tuchenhagen, in which a member of council for the city of Thunder Bay expressed an interest in a tax property sale to be disposed of by city tender. People don't pay their taxes, it's going up on the auction block. The court had determined if the member had an indirect pecuniary interest within the meaning of the MCIA, because he expressed the interest by email to perhaps put in an offer on the property and requested from staff a copy of the advertisement and wanted to set up an appointment to view the property. The member was a member who bought properties. I believe it's casually known as flipping them. And that's fine. You're allowed to do that if you're a member of council. But if a member has a private interest in a matter before council or committee, then the decision is tainted and they must step away. Council had to decide to remove certain criteria and then put the property for tender and sell it as a tax sale. Making that decision when already a member was thinking they might want to buy it presented a conflict. The expression of interest was made by the council by email to a staff member requesting a copy of the property specs. He said in the email, "I may be interested in bidding on this property." He hadn't decided that he would or would not, but there was already a conflict, said the court. The court found that the counselor had breached the MCIA. He was no longer a counselor at the time of the decision of the court. So the court disqualified him from being or running again for 4 years so that he wouldn't run in the next election. And he was also ordered to pay about $9,000. So what constitutes a pecuniary interest or a conflict? Financial or personal interest in a matter sufficient by the reasonable standard to trigger the provisions of the MCIA. It captures almost any financial or economic interest of the member. There are exceptions contained in Section 4 of the MCIA, most commonly a pecuniary interest in common with electors generally, or remote and insignificant. But generally, you can't sort of take a swath and say, this is what a conflict is. You all have different circumstances, and this is why the MCIA now says that members of council elected and appointed, if they seek advice from the Integrity Commissioner and rely on that advice, if there is a challenge, so a code complaint or an MCIA complaint to the IC or to the courts, that will be a saving provision, meaning for a member of council, they won't be kicked out of office because they sought the Integrity Commissioner's advice, and for an appointee, you will not be removed from your position if you relied on the Integrity Commissioner's advice. Next slide, please. Foundational principles. Members are tasked with carrying out a portion of the discussion and outreach that will then form the recommendations to council. And ultimately, your recommendations, so your advice giving, will be considered when council makes decisions for the township. You're required to adhere to the principles of fairness, avoidance of bias, and undue influence. In a case, Bose versus City of Toronto, the court said, and I quote, "It is incumbent on a member not to place him or herself voluntarily in a position in which, while retaining the office of advising or decision-making, as the case may be, he or she would have a private interest that might be opposed to the unbiased performance of his or her duty." Next slide, please. So you most definitely can have a perspective and an opinion that differs from your colleagues. That's why you're there, because you know about things germane to what the task, the advisory committee has been struck to review. However, championing a position may be perceived as prejudgment or bias, contrary to the rules of the code, if it were adverse to the recommendations of staff, who are the experts in the municipality. So you may be an expert in your sphere of your work, but the staff of the municipality have been hired to provide expert advice on certain matters, including planning matters. And so if you champion a position that is adverse to staff without reason, and you have a private interest, this may trigger the MCIA or the code. In a case, Guimond versus Sornberger, it was an Alberta Court of Appeal case. And to be clear, even though most integrity commissioners take a look at the decisions of the Ontario Court of Appeal or Div Court, you look where there are governance best practices. So in this particular case, the court said the elector has a right to the even-handed, independent consideration of his elected and appointed representatives on questions before him, unaffected by influence that could potentially flow from a direct or indirect pecuniary interest. The only question permitted to be asked, the court says, is whether a pecuniary interest exists, whatever its extent or degree. We have a little bit of a difference in Ontario because there are exceptions. It could be common with other electors. It could be remote and insignificant. You could be an appointed member of another committee, but generally speaking, is there a pecuniary interest? And if there is a pecuniary interest, there's a presumption that you have a bias. It's irrelevant to inquire whether the member cast his vote against or for their interest. He may have voted favorably for his pecuniary interest, or he may have, and the court says, leaned over backwards and voted against it, just to show everyone that he doesn't have a pecuniary interest. The latter, the court said, may be acceptable morally, but it does not achieve the disinterest consideration of the question on its merits, which the elector is entitled to from their elected representatives and which the statute commands. Pecuniary interest, reasonable person believes that it will affect your decision-making. Financial interest, you do not vote, you declare, you do not try to influence. And even if you feel that you're acting in the best interest of the municipality, the law requires that you recuse yourself. Next slide, please. So what are you supposed to do if you have a pecuniary interest? Well, you must disclose the interest prior to the meeting, not take part in the discussion, not vote on the matter, not attempt in any way before, during, or after to influence the vote. So to influence your colleagues on the committee or staff who may be bringing forward recommendations. And if the matter is subject to a closed meeting, you have to leave the meeting. And if you were not present, as I mentioned, you may not have looked through the package, you were on vacation or what have you, then you have to declare your conflict at the next meeting of the committee. The MCIA imposes obligations on a member where he or she has an actual, perceived, or potential conflict of interest. And those depend on your circumstances. So, I know people are thinking, well, give me an example of an actual. Well, it depends on your circumstances. And I'll go into that in the scenarios. A member is personally responsible for identifying whether they have a pecuniary interest in a matter being discussed at council. So you don't ask the clerk representative, another member of council or committee who may know a bit about conflicts of interest might lean over and say you might want to consider that, but the responsibility is yours to determine if you have a pecuniary interest. And if you sort of lean across and speak to one of your colleagues and he or she says, yeah, I don't think so because I spoke to somebody who is a lawyer downtown and they said, no, that's not a conflict of interest. You can't rely on that if there's a code complaint or if the matter goes to court. Next slide, please. So this slide just says what your obligations are under the MCIA. Stated it before. Influencing a decision can be nuanced. That do not attempt to influence. And I can point that out to you in a decision where a member was alleged to have had a conflict of interest. And prior to the meeting, he made a statement. So he said, you know what, I'm going to declare a conflict, but I've got a statement. And he said, even though I strongly believe that this is important and appropriate to me as a councillor, and you can fill in the blanks appointed member, to address the common good of the owners of the 40 properties who have the ability to consider comprehensive development zoning as an option to them, I must address, and then there was a long pause. This is actually in the transcript. This is not me doing theater. Long pause, a matter of importance to my safety. There has been harassment and intimidation over the past months, and hence I will not be participating in the discussion. And then he left. So the court found that he breached the MCIA because the court said he somewhat defiantly stated that he wished to address the common good of the property owners who had the ability to consider this zoning application as an option, but that as a result of harassment and intimidation, he would not participate. The court said that his statement, they took it, to be an attempt to influence the vote of the committee by suggesting that what was before the committee was in the best interest of the district and that he would have voted in favor of the application, but for the harassment. Whether or not he was attempting to allow fellow, and this is the court speaking, whether or not he was attempting to allow fellow committee members to draw the conclusion that those opposing the application were somehow responsible for his harassment and intimidation, the court said was unclear. But the court said it was an emotional statement and it was made by the member with the clear impression that he thought that the vote should be in the best interest of the district to approve the zoning amendment. And so the court found that he had attempted to influence the decision in contravention of the law. Next slide, please. So only a court can decide if the MCIA has been breached, and the IC can determine if there likely was a breach. So if I receive a code complaint that a member of the planning committee has allegedly breached the rules of the MCIA. Under the process of the code of conduct, I will review the matter, and I have two options. I will either, with reason, say I believe that the member likely breached the MCIA, and I will be referring it to court, and that referral and application by the Integrity Commissioner is paid for by the Township of Georgian Bay. So the Integrity Commissioner is stepping into the shoes of an elector, or I will give reasons why I believe that it's not advantageous, in my opinion, to refer the matter to court. I can't make a determination on whether you have breached the rules of the MCIA, but I can give you advice on whether I believe that your circumstance will trigger rules of the MCIA. A judge may determine, once it goes to court, that there be a reprimand, a suspension of pay for up to 90 days, declare the member's seat vacant if they're a member of council, remove the member from the committee if they're an appointee, disqualify the member elected or appointee for up to 7 years from election if it's a member of council, and from being appointed to a committee of the township if it's an appointee, and if there was financial gain, restitution. The saving provisions, so the way that the court will say, we're not removing you from office or taking you from the committee, would be if it was committed through inadvertence. So it was a mistake, and there are examples in law of when that happens, or an error in judgment in good faith. So I think I won't go into detail here, but it's important to remember that this is almost a quasi-penal statute, and there are some harsh consequences to ignoring when you have a conflict of interest. Next slide, please. I think this is my last slide before the scenarios. Yes. Reasonable apprehension of bias. So it is not a code contravention to have an opinion. I hope I've made that abundantly clear. You can speak your mind. You can disagree with respect. You can bring in new ideas with respect. Even a strong idea and a dissenting perspective that differs from the perspective of your colleagues is allowed. However, the code requires a member to be mindful that you're bringing forward of a matter when adverse to the recommendations of staff, the public, other members of committee, in the presence of a financial or personal interest, will trigger either the code or the MCIA. You must be impartial and appear personally disinterested in the outcome, except as it relates to a reasonable review of the information before you. Otherwise, your recommendations and the resulting decision of council from your recommendations, relying on your recommendations, may be tainted by a reasonable apprehension of bias, challenged and overturned at OLT or in the courts, and the damage to the township's reputation and the financial burden to the township may be significant. So those are my high-level overview rules that I'd like you to consider. I'm going to pause for a moment before we go into the scenarios, but the scenarios are really good. So unless there's a burning desire to ask a question now, Chair Hazelton will just go to the scenarios. I leave it to you.
So thank you, Suzanne. And I'm not seeing any burning, flagging, waving hands. So please proceed with your scenarios.
Okay, thank you. All right. So I just have so many code complaints, and you know what, you all live in the district of Muskoka, so I decided to bring these two forward. One was a formal complaint that was resolved, but it was widely distributed amongst members of the community, so everybody knew about it. And the second one also, so even though I did not bring forward a report to council, it was well known in the community, so I don't believe that I'm disclosing anything, and I haven't mentioned names. So even if you think you know who it is, I can say I neither confirm nor deny. So let's quickly go through the scenario. I'm going to sort of read it just because I gave it to you today, and so you may or may not have had an opportunity to look through it. So I received a complaint. A member of the community said, please take a look at this realtor brochure and tier sheet. These are the actual comments that they used. where our mayor has welcome to the community and thank you for, et cetera, et cetera. And by the way, I'm also a real estate agent and here are some properties. The complaint said, in particular, here's a cottage for, quite a sizable amount of money. And they said, recognizing that the commission for the sale is more than it would be the mayor's salary, can you let me know if there's a conflict of interest? So high level, my response was, with respect to the circumstance of the member being a realtor or a sales representative, I said that there was a court case, Superior Court of Justice, that addressed this issue. Campbell versus Dowdle, a member of council, Mr. Dowdle, was also employed as a real estate salesperson. He listed 4 buildings for lots for sale for an individual, Mr. Brown. An application by Mr. Brown for permission to remove topsoil was brought before council, where Mr. Dowdle had declared conflicts before with the topsoil issue. He did not. The court stated, while it's difficult, if not impossible, to say with any certainty what monetary or money-related consequence the disposition of topsoil removal application could have for Mr. Dowdle, Councillor Dowdle, he has a connection to the land in question, and it is a money-related connection. Mr. Dowdle was, at the time of the matter, before council, an agent for the principal who was trying to sell building lots. If the lot in question was sold, the court said Mr. Dowdle or his employer would receive a direct financial benefit. The court concluded by stating that they did not think that the pecuniary interest could be said to be remote or insignificant because it was topsoil. They considered the argument of Mr. Dowdle's lawyer that topsoil removal applications are, in the scheme of things, minor, routine. They're not really huge planning matters. But the court held that the reasonable elector would inevitably fear that the councillor's discretion concerning almost any public matter involving the lands for which he had listings could fetter his decision-making authority and create a conflict of interest. So, the respondent councillor in this particular case disclosed interests before, but didn't with the topsoil. And the applicant applied for a declaration of removal of office and a disqualification for 6 years. The court found that when the matter of permission to remove topsoil from Mr. Brown's building came before council, the member should have declared an interest because there was a financial connection. He had listings for the properties, or at least his brokerage had listings. And the court said that the appellant's interest, in our view, is neither too remote nor insignificant. It doesn't matter how important the removal of topsoil is because there is a pecuniary interest. In the Dowdle case, the broad proposition advanced on behalf of the applicant, so the person who brought the case against the councillor, was that a member of council who is also a real estate agent will always have a pecuniary interest in matters of land use, such as zoning, severance, subdivision, and the like, even in the absence of a direct business connection because of the potential for increased activity in real estate. Mr. Dowdle, the councillor's lawyer, argued that taking this position would bar all councillors and appointees with any involvement in business in the municipality from participating in development decisions. Lawyers, insurance agents, contractors, builders, he said, all have the potential to benefit in a pecuniary sense. The court found in this Dowdle case that in order to find a pecuniary interest on the part of a real estate agent in a matter before council involving land development, there would have to be something to connect the individual to the particular matter beyond the mere potential for future business. Just what that connection might consist of goes well beyond a commercial contractual interest. You don't have to have a listing. And the court said, but definitely having a listing will create that financial pecuniary interest. In the circumstance of the Dowdle case, the court said that Mr. Dowdle's failure to declare pecuniary interest in the topsoil matter was an error in judgment because he and his lawyer felt, you know what, it's topsoil. I'm not really going to make more money one way or the other, but the court said it was not insignificant, but it was your error in judgment in thinking it was insignificant. You still breached the act, but we're not going to remove you from office because it was an error in judgment. Don't be doing this again. So getting back to my code complaint, I found that in order to establish a disqualifying bias on the part of the mayor, in my case, there had to be evidence that the position taken by a member was incapable of change. So he was a real estate agent. He got to be mayor. He got to be a real estate agent, but he had to be really careful that any of the development or rezoning applications that came before council or any committees that he was on, he did not have listings. His brokerage did not have listings. Some of the affiliate organizations that he worked with did not have intent to list. So I told him, you know, you've got to tread carefully. With respect to having his picture on the welcome to the municipality, and by the way, I'm selling some cottages, I said that there was the blurring of the lines. I advised the mayor that the line between his private commercial endeavors and his role of mayor, he was using his title, and that carried a lot of weight. It got him indoors that others may not, and it was tantamount to using his position of office improperly to influence to his advantage. So that's the first scenario. Do we have any questions before I go on to the second scenario?
Not seeing any.
Okay.
Thank you.
Yeah, I've got 10 minutes. I'm going to rush through this. Thank you for that. So the second scenario, another code of conduct complaint that I received. Obviously, you can tell these are municipalities nearby you. So, you know, you may have similar situations. I don't know. So the spouse of a member of the municipality sustainability advisory committee, her husband is a general contractor. So the sustainability committee had been working prior to me receiving the complaint to make recommendations to council regarding property development water setbacks. And I apologize if I don't know the exact technical terms, but you get what I'm trying to say. And the location of septic systems. Experts had provided consultant reports to the municipality advising that development allowed too close to the shoreline may pose a contamination risk to water and species if sewage seepage occurs through a breakdown of the walls or in the steel cages. A member of the public asked me to look into this to see if the member should declare a conflict of interest because her husband is the owner of a large general contracting company. And most of his clients, you know, either buy big cottages or renovate cottages that are existing there to build the use was dream home. The complainant believed that the member would cast her vote, raise discussions, take positions for minimal setbacks and allowing septic systems to remain where they were to be built close to the shoreline because this would facilitate ease of business for her husband. The complainant believed that the members position a committee to build up around the shoreline while leaving the septic system in place instead of removing it would benefit her husband because in that municipality, there wasn't a need to get a septic building inspector report if you know you built around it. So it was easier. So my response was, first of all, Section 3 of the Municipal Conflict of Interest Act contains a non-rebuttable presumption of deemed pecuniary interest, meaning you've got a pecuniary interest. There's no argument. If the individual who has the pecuniary interest is your child or spouse or parent, no argument. There's no rebuttal. You've got a pecuniary interest because your spouse or parent or child does, so you do. As set out by pardon me, municipal law experts, partiality by reason of prejudgment must be distinguished from a personal interest. Some degree, as they say, municipal experts who created the Ontario Municipal Law Users Manual, some degree of prejudgment is inherent in the role of council or a committee member. That is not the case with respect to interest. There's nothing in the function of council or committee members' role under the Municipal Act that makes it mandatory or desirable to excuse them from the requirement that they refrain from dealing with matters that have a personal or other interest. It's not the role of a member to be personally interested in the matter that comes before them beyond the interest that they have in common with other citizens. And where such an interest is found, both at common law and statute, the member is disqualified from participating. Even if no direct pecuniary interest is found, the experts say the appearance of conflict of interest through having a personal interest in the outcome may be sufficient to disqualify a council or committee member on a particular debate. And so the fact that the member's spouse's business and therefore his financial options relate to construction of large cottages near the shoreline and the requirement of obtaining septic inspections for the removal of or situating of septic systems will significantly erode the profitability of the spouse's business profits, even if he's not found to have, even if she was not found to have a pecuniary interest, I'm sorry, that should have been she, in the discussion of the matter, the spouse, and therefore she, will have a private interest. Thus, the member will have a deemed pecuniary interest at a minimum, disqualifying private interest under the code that may trigger for the decision of council down the road. So we're going to have build up around the septic systems or build right up to the shoreline, a reasonable apprehension of bias, because the decision of council was based on and relied upon the advice of the Sustainability Advisory Committee. And so let me just finish by saying that the circumstance in this scenario that I dealt with, and I had to consult with a bunch of people, it wasn't just me looking at the cases, demonstrate how the financial interests of a member, in this case the member's spouse, are inextricably linked with the issue of development of shoreline properties. This is not a hypothetical future business. Maybe there'll be, cottages built. The size and location of the properties that the member spouse's company builds or renovates were very few. It was top shelf building, and there were very few locations for the types of cottages and builds and renovations that he did. So it is not an interest in common with all electors. It's not everyone who builds a cottage, they might have to move their septics. It's this particular builder because of the type of work he has. While many properties have along the shoreline, issues that may be similar, this is not a community of interest. To avoid septic inspections would have involved particular need for permits for large builds. This matter may be defined, and I did define it, as a special non-pecuniary interest by virtue of a business's association with a real estate agency, because the member spouse also was mentioned on the webpage of a real estate brokerage. This doesn't disqualify the member from office. She can still be on the committee and in office, but it would render any decision in which she participated as it related to her spouse, subject to being set aside. Thus, in this situation and those like it, a member may have a common law non-pecuniary interest in a discussion, and there doesn't need to be impropriety. It doesn't mean that the person is a bad person. It is about that interest, that financial interest or private interest of being present, and therefore a need for the member to step aside, not vote, and not influence. So I'm going to stop here. I think I've got 2 minutes before the hour. I thank you for all of your interest in this. I guess I just want to finish by saying it's about not wearing two hats. You can have a perspective, but you've been appointed to serve impartially and act in the public interest. It's a privilege to have this role, to be able to participate in the decision-making of advice to council. So I thank you for taking on this role, and I thank you for giving me the time to speak with you today. Over to you, Chair Hazelton.
Thank you, Suzanne, for this. And we are going to go to questions. Hopefully, do you have a few more minutes?
I do. I just didn't want to take longer than an hour speaking, because listening to me can get old.
Okay, so we have had one question come in to the clerk, but I'm going to go with hands first. And David Clark has a question. So David, over to you.
Good morning through the chair, and thank you very much, Commissioner Craig, for your presentation. It was very insightful. I just have two very quick questions. So where committees can seek the advice of the Integrity Commissioner, is there a cost associated to that as there is with investigations? Or is that a service that the office provides?
Through the chair, and thank you for your question. So I'm always mindful of that. And let me just add that years ago, when they were looking at the ledge, the province was looking at amendments to the Municipal Act, the Municipal Conflict of Interest Act. I was asked by one of the policy committee members, how much do you make? How much do you charge? And I told them, because if you are serving the public, which I am, you have a right to make money, but you also have a right to realize that you're working for the public. And so, in answer to your question, I have a very small stipend. I think it's $2,500, and with that $2,500, I take general questions. I have a per hour fee that I charge for code complaints, informal, formal, or mediation. So generally speaking, telephone call, email, do I have a conflict? It's included in that general fee that I charge the municipality.
Okay, thank you. And then just a quick other question, if I may. In relation to conflict of interest, and we're on a committee, if a matter comes up, is your area of residency, whether it's your full-time residence or your cottage, does that come into play as far as declaring a pecuniary interest or a potential conflict?
Through the chair to you, Member Clark, it's your financial interest. So quite frankly, it doesn't matter whether you live in Mississauga and have a cottage in the township, you have a business. Quite frankly, if you stand, or a relative or an associate or your employer has some financial loss or gain in a matter, doesn't matter where your residency is.
Perfect. Thank you very much. Through the chair, I'll hand it back to you, Al.
Thank you. Next, Brian, you wanted to ask a question.
Yes, and thank you, Ms. Craig, for presenting today. As a counselor, I do have a question, and certainly if it was in particular, I would contact you in a particular case. But you mentioned the fact of a spouse having a connection through real estate in the sale, and that is of concern. And I'm just wondering about the amount of distance between the counselor and the person that would be, say, the real estate agent or the contractor. If your spouse were to be an employee of that person, would you have a pecuniary interest in voting on a matter, as opposed to if your spouse was a subcontractor, say a carpenter or a welder, a subcontractor, and worked for that particular company? Would there be a difference between your spouse working for the company or your spouse being a subcontractor to the company when it comes to, and how far of a distance do you need to not have that conflict?
Through the chair to Councillor Bocek. Couple of points there. So it is not so much the distance as it is the remote and insignificance of the financial interest. I'll just give you an example, and then I'll go through the points you just gave me, sir. There was a gentleman in a municipality. There were matters that were coming before council as it related to a minor variance for property. This individual's son did, occasional grass cutting and worked for a company that cut the grass for many locations, including this property. And the person said, well, do I have to declare a conflict? And while he had a pecuniary interest, because it says if your son has a pecuniary interest, it's yours. But it was so remote, given the quantum of the individual's payment for cutting grass, and also the decision to be made by council would not impact if this company would continue to cut grass. So maybe he cut that particular property And maybe if they were going to asphalt the whole area, not have grass, he wouldn't be cutting there anymore, but he'd still be cutting other properties. So I found that he had a pecuniary interest, but it was remote and insignificant. In the event of a member of council having a spouse that is a realtor, if they work for the realtor or the brokerage company, and the property that is listed by the brokerage, maybe not by the spouse, but by the brokerage, it's still an indirect conflict of interest. If the spouse is a contractor for the brokerage, if I understood correctly, and so they're doing carpentry or renovations or design for properties to beautify or following the purchase, the question to ask is the same as the grass cutting example. Would the spouse who is subcontracted out to do information, would that person's financial interest be significantly impacted by the decision council has to make? And based on that answer, I would determine whether or not it was remote and insignificant. There's a financial interest. If the member has a spouse, parent, or child who in some way has an economic interest, as I said in my presentation, there's a presumption of bias. However, it may be remote, sufficiently remote and insignificant that it wouldn't require the member to declare a conflict.
Thank you very much, and appreciate your answers.
Thank you.
Thank you. I'd like to move on to Councillor Graziano, and then Armin has a question.
Ms. Craig, always a pleasure seeing you. Thank you for attending today. And through you, Al. The question pertains to a potential conflict after the fact. And so I'm going to give you a scenario and curious to know what your thoughts are. Let's say for all intents and purposes, a spouse works on a specific planning matter, as an example, concludes their work on that particular file, and that then comes to council after the fact once they've concluded their work on that file. Is the council member to recuse themselves given the fact that the spouse had already worked on that particular file, or have they cleared the potential conflict, and are they not required to do so? So over to you. Thank you.
Thank you through the chair to Councillor Graziano. So in a short answer is there you're cleared, or the member or appointee is cleared, because jurisprudence has identified that the financial interest of the spouse, parent, or child has to be immediate and has to be present, sort of the same thing, and cannot be a future dealing. So the spouse has already done work for the company or for the property. The matter is now before council. The fact that they have done work, they have had a financial interest in an economic interest in the matter, it's done. So what the MCIA is saying is, you're deciding on a matter where your spouse may gain or lose. They've already gained or lost. And so no, you would not have to declare a past relationship. However, if the spouse is a contractor, independent professional, and has an ongoing as needed relationship with the company, and only you would know this because, or the member of council would know this. So they from time to time are called in by the company to refurbish, to contract, to whatever the work may be. You have to take that into consideration. So it's done. They may not be called back for a couple of months, but will the callback, do you feel that the callback may be influenced by your decision? Because now they want to have an application for a building of a condo near the shoreline. And that means in addition to the past work, there might be a whole bunch of properties that the spouse may be asked to work on. So again, the MCIA does not deal with hypothetical, it's a future, but how is that relationship contracted? So no with the past, maybe with the future.
Follow-up question, if I may, Mr. Chair. Thank you, Madam Ms. Craig, for the response. And so my understanding, if I can see clarity here, is that regardless of the timeline, if the interests conclude and 5 days later the matter is before council, there's no issue there? Or is timeline a factor of consideration? And how close to proximity of that conclusion date could there be a potential pecuniary interest? And then second to that, as you've articulated, I'm assuming if the person is retained for future work, then there could be a potential conflict there. But how would the person be aware that there could be potential for future work unless otherwise retained?
So thank you, through the chair. So the first part of the question, anything that has happened, if the person has received their payment, it's done. Now, there are circumstances where there's a holdback in payment. So the person has done their work, they've been paid, the contract for all intents and purposes is finished. But now the matter is before council, and council says, well, you know what, you need to have that wall moved, or you need to have that flooring redone. This individual, although completed their work, there's a holdback in payment, and the company or the individual might say, hold on a second, we need you to do that. Again, it is a circumstance that person will know. So they need to ask their spouse, are you done with that project? And if the spouse says, well, they still need to do I forget what the term is in real estate or what have you, but they have to make sure that everything's done properly, then they're going to give me my final check. Therefore, there's still a financial interest. With reference to being retained, you will look at the pattern. So if it is, we might call you back in the future. We might need your services in the future. Again, the act is very clear. It doesn't want to tie people's hands. So a future, maybe we'll hire you again for good work, does not bind the member of council and create a pecuniary interest. However, if there has been an ongoing, on an as-need basis, and they come back to this person, the spouse, frequently, and I can see through the information provided to me, either through a complaint or by seeking advice, that this person over the last 2 years has been retained by that company several times. There's a pattern and a likelihood that is not remote and insignificant that they will be hired again. And therefore, there's likely a need to declare in an abundance of caution.
Thank you, Ms. Craig.
Okay, Armin.
Thank you, Chair Hazelton, and thank you, Commissioner Craig, for appearing today. It's answering a lot of questions for everyone, and just wanted to ask a question and give some context on my. I'm the person that's been being talked about a bit because I'm a local contractor since 1975, and I'm also a local realtor since 1992. And I served on council for the Township of Georgian Bay from 91 to 94. Since I was on council, and I've been asked a number of times over the last 25 years or so to serve as a member of the Planning Advisory Committee on an as-needed and ad hoc basis from time to time. I believe I was asked to be a member of the various committees because of my experience in these matters. During our meetings, I'm frequently asked to give my opinion based on real-time, real-life examples of how well specific zoning bylaw and official plan provisions are applied or how they're working. I routinely make recommendations on changes to zoning bylaw and official plan provisions when asked, in an attempt to make the provisions more effective and more relevant. And before accepting my original appointment and every time thereafter with the various councils of the day, before accepting appointment to the PAC, I asked the clerk whether or not, based on my vocation in our local community, I would be in jeopardy of a conflict of interest. I was told that no committee member rules on specific matters like a councillor would, but only makes recommendations to council. And that those recommendations don't have any influence over specific cases. I wanted to have your opinion on whether or not, as a committee member making recommendations along with my fellow committee members, whether I might be in jeopardy because of my standing in the community.
Thank you, sir. Through the chair. So first of all, I can't comment and won't comment on what advice or comments were provided to you by staff. What I can say is that advisory committees, and I pointed this out in one of my examples with the sustainability committee, advisory committees advise and they make recommendations. And the genesis of a council resolution, a council bylaw, a council decision on direction to staff for an OLT decision or direction may have its genesis at the advisory committee level. And so while you do not, and you are correct, and advisory committee members, the committee doesn't make decisions, its recommendations will be the genesis of decisions of council. And so it would be incorrect to state that a committee member, because the committee doesn't make decisions, therefore there's a reason why committee members, local board members, are captured by the governance under the Municipal Act of the Municipal Conflict of Interest Act and the code, because you may have a pecuniary interest and you may have a code bias. That is clear in law. The standing in your committee is not what creates the pecuniary interest or the disqualification, but rather, as I pointed out in the Dowdle case, the connection with a real and present business transaction or relationship with a developer or an owner or a contractor. So as I pointed out, and as the courts have pointed out, many members of council, many committee members are lawyers and insurance brokers and mortgage brokers and contractors and landscapers, build docks, build boats. That is not a disqualification for holding office as a member of council or being appointed. However, if there is an immediate, real, and present connection, business or otherwise, as pointed out in the example, I build big cottages along that shoreline. We don't know if we should have A or B. That's going to affect that particular individual. And so that individual has to look at the appearance of impropriety in continuing to give their advice. My recommendation is, with the experience that one may have, to lend to the committee. Don't take that away from the committee. However, please seek my advice, because circumstances may be such that an appearance of bias is there.
One further follow-up, if I may, through you, Chair Hazelton. Our Planning Advisory Committee does not rule or make any specific recommendations on real-time applications, or, like if it's a zoning bylaw amendment or anything like that. We're basically, I believe, we've been retained to sort of add context and add information on basic policies that are stated in the zoning bylaws and so forth, and we're not ruling on a particular case or circumstance. Is that still, would your advice still be the same?
Through the chair, yes, it would. Example, very far and different. Integrity commissioners, they are retained for their experience. Let's say there was a committee of the province, hypothetically, looking for input from individuals who have experience. And they said, what do you think about having a panel of experts who might serve not a bunch of integrity commissioners, but maybe 5 or 10 that if there is a possibility that that recommendation, I'm not making the decision, the province is, but I have an interest in the matter that will be decided by the province because I'm an integrity commissioner. And if they decide that they're going to have 5 integrity commissioners and I'm one, that's going to boost my income big time. So am I a bad person for wanting to give my experience? But in that particular question, I will refrain from giving an answer because I have a financial interest. So, your situation is not unique to municipalities. It may be unique to your municipality. To be very clear, you started your statement by saying, I'm the person who's being talked about. Sir, I do not know you, and I certainly have not received a complaint from you, but I do serve many municipalities, and I have circumstances that do dovetail in what it seems that you deal with. And so I would be happy to talk to you offline, but certainly a planning committee member, even though they don't make decisions, do start the discussion that then becomes a resolution of council or a decision of council.
Thank you very much.
You're most welcome.
Moving on to Beth, you had a question.
Thank you, Chair Hazelton, and very nice to meet you again, Ms. Craig. We actually met in the council chambers, I think it was pre-COVID. I've sat on this committee since 2013, and we did have a conversation about the importance of coming here, and this was a great presentation today. I have a couple of questions, and one is related to what Member Gergaitis just mentioned, as in we had been previously advised, because we were an advisory committee, that we didn't have a conflict, and that has been for some time now. Was that misinformation, or did something change in the legislation that has changed now your view? And I will say, the first time I sort of got an inkling that it wasn't as we were so told, when you provided some guidance at district council back at the beginning of this term. Did something change that triggered that change of view?
Thank you for the question through you, Chair Hazelton. The Municipal Act changed to give the Integrity Commissioner broader powers in 2019. I don't know when you received that advice, but there are new powers of the Integrity Commissioner, and the Municipal Conflict of Interest Act also, as the changes to the Municipal Act happened. So I don't know that there was a specific change, because local boards and committees, but there was a clarification in the Hansard notes that this is what this is going to mean. So there was a change, yes.
Thank you for that. Another question I had was, you talked about when there is a declaration of a conflict, whether or not a member has to leave a meeting. I kind of understood it from the initial slide that yes, they did need to leave the meeting, but then on a later slide, it was only if it was an in-camera meeting, perhaps they had to leave. Is there some clarification that you can provide? If there's something that a member has declared a conflict, do they still listen into the conversation, or do they have to totally remove themselves?
Thank you, through the chair. So to clarify, and my error, there is a need to declare and to not participate and to not influence before, during, or after the debate and vote. And so while the Act doesn't say that the member has to leave the council or committee location, only in the case of a closed meeting, there have been decisions of integrity commissioners and courts that have said, listen, if you're sitting there and it doesn't matter if you're listening, it's not so much the listening, but the influencing. It might be the sitting back in the chair. It might be crossing the arms. It might be, well, I can't believe you're saying that. In whatever way, your gestures, your tone, your pacing back and forth, or even intimidating. I have had situations where a member has just glared at another member. And so they're not saying anything, but they are certainly suggesting that, you might want to check yourself. And so it is advised that members of council and committee, when they have a pecuniary interest under the MCIA, leave where that discussion is happening. It is required if it's a closed meeting. It is highly recommended if it is an open meeting.
Thank you.
You've gone quiet, Beth. Beth, hello, can't hear you.
Sorry. Thank you, Chair Hazelton. Just one more question to ask. Occasionally, topics come up at our planning committee where there's a lot of dialogue, and perhaps there's additional information that can be provided to staff. And if a member says, well, I would like to have a one-on-one session with a member of staff to talk about this further, is that an issue? Is that a potentially problematic situation?
Thank you. Through the chair. There is a council staff relations policy that applies also to appointees on committees that sort of sets out the relationship between staff and members of council and committees. Again, the code is never in place to prevent you from a free and frank discussion with your subject matter experts, which are staff. However, staff are directed through the CAO or his delegate, and that might be the director. And so it's prudent if you just want an update or a clarification. You may know the staff person. Not my call to say don't reach out to staff, whether you're a member of council or a member of committee. However, there is a chain of command, as it were, that communications with staff. We might need more information. We heard a lot from the members of the public. Can you maybe get me those types of requests for further information and clarification should happen at committee. And if not, through the CAO or his delegate. And so informal clarifications can happen. Phone call, email, not quite sure about this. Can you point me in the direction? Really, you want ease of information, so you don't want things to be too robust, but your staff have priorities and they have to follow those. And like it or not, a member of council or a member of committee, there is an imbalance of power. So you may see it as just reaching out and asking a question. They might find it hard to say no.
So what I did make a suggestion on one occasion was if there's information, and often staff ask for additional feedback or point us to some areas that you may have talked to at a meeting. I did make a suggestion at an earlier planning committee meeting that if there is communication with staff, that it is shared with all the members of the committee, and then we are all open and transparent of those discussions.
Again, that's a staff decision. On the basis of the staff council relations policy, that may be included. Reasonable requests to staff are reasonable requests. And so it would be within the purview to make a determination, but asking that question is definitely not a code breach.
But is sharing the information, if there's additional augmentation of detail, is that something that should be shared with all the members of the committee, I guess, is really what I'm not asking the question, but
through the chair, that's not within my determination, decision making. Municipal government should be transparent. Picking and choosing which member of council gets what information is not great governance. But how staff deliver and provide information to members of council and committee is up to staff.
Thank you.
Thanks again. I'm not seeing any other hands. I have two questions that have come in from the public or from the community. Suzanne, if I could just ask you, I know, put you on the spot a little bit here, but one of the questions relates to the city of Mississauga, who appear to have a policy where they do not accept contractors to sit on committees or committee of adjustment because of their potential for pecuniary bias. And their policy apparently is that they would seek to bring in contractors to get their input on given matters, but wouldn't embrace them as a committee member. So that kind of touches on some of the conversation today. Is it too much to ask you to weigh in on that?
Through you, Mr. Chair. The eligibility criteria of committee members is within the discretion of your staff and council. And so that would be something you would determine. I do know, having served many municipalities, the committee of adjustment is a little different than advisory committees, because as one of or several of you have pointed out, committee of adjustment makes decisions on rights of individuals and their property rights. It's a quasi-judicial tribunal, and so there cannot be an appearance of bias. And so there's a conflict check that is usually run, and most of the terms of reference of committees of adjustment set out who can and cannot be a member of the committee of adjustment. And if they are, a planner or an engineer or a contractor, what they can and cannot do. So there might be a privacy shield. So for their term as a committee of adjustment member, they receive mail from, their employer, but not relating to the municipality of fill in the blank. I think these are things that you need to look at. I have advised in my governance expert capacity that terms of reference are vitally important. It sort of scoops out these issues from the front end, gives clear expectations to members that they should not feel that because of their experience or their knowledge, they're in some way seen as having some sort of insider scoop. But at the same time, there is the potential for triggering MCIA and code. So with Committee of Adjustment, 100%. 100%, I know that of at least 3 municipalities that say you cannot be a contractor. They just won't allow it. And that might have a lot to do also with the Cunningham inquiry, judicial inquiry, where, with the dealings with the former Mayor McCallion's son, that they were given recommendations on best practices. With other committees, such as yours, I think you have to take a deep dive into what some of the other jurisdictions do and why, and look for best practices.
Thank you very much. We had a question come in. It's not specific to the Planning Advisory Committee, but it's from our chair of the Committee of Adjustment. And given that we've been talking around these kinds of things, if I could just read the question and you could offer a comment. So the question is, if the mayor of a township presents an application before the Committee of Adjustment for a minor variance, do any members of council who may be a member of the Committee of Adjustment automatically have a conflict of interest or pecuniary interest, and are they required to declare?
Thank you for that. So two things I'd like to say: that if the chair would like advice from me, he or she may certainly reach out to me. I don't love giving advice sort of at the dais, but because I'm here to sort of give you education, I'm happy to sort of generally provide a response. So the MCIA is very clear. There is a pecuniary interest direct of the member or his or her employer, or if they have shares in a company. And then there are the familial. There is parent, child, spouse. Doesn't talk about friend, doesn't talk about work associate. So by virtue of knowing and working with someone, that does not disqualify you from making a decision or deliberating on a personal interest that they may have, in this case, under the Committee of Adjustment. If you do have more than an informal work or friendly relationship with an individual, i.e. they might be your brother-in-law, or they might have gone to school with you and you guys have a very deep relationship. Sometimes you buy property together, sometimes you go on vacations together. So there is an affinity that creates a personal relationship that a reasonable person may feel disqualifies you from an honest and open, impartial decision making. That may pose a code bias, but it's a very big may, because there would have to be an outstandingly tight relationship. The fact that you're all on council, if somebody brings a personal matter to the Committee of Adjustment, does not disqualify any of you from participating in that discussion or debate, and definitely not under the MCIA.
Thank you for that. And I have a question. And my question is, as chair of the Planning Advisory Committee, I often hear from community members that they believe that there is a conflict either by another member, or if I'm sitting on council, I will have residents tell me, your other councillor has a conflict. And so I think what I heard you say earlier is that only the member can confess, if you will, a conflict, or can claim a conflict. And we as councillors or members do not have the ability to tell another member or councillor that they have a conflict, which is an interesting challenge, because I think the only path then to dealing with conflicts is to create a challenge and submit that to you, and have you then adjudicate that that issue. Am I understanding this process properly here?
Through you, Mr. Chair. Yes, and just very briefly, a member of council in the decision that I mentioned, Mondu and Tuchenhagen in Thunder Bay, the court stated that the decision of whether an individual member or appointee has a conflict of interest under the MCIA is a personal one. And so neither staff nor other members may say, you've got a conflict, you shouldn't be here. We're going to mute you. Please leave the room. And in order to challenge an individual who believes that they don't have a conflict when in fact they may, the routes are informal code complaint, formal code complaint, or going to court. Now, we don't always want to get into formalities, nor do we want to spend a bunch of money. And so if a member believes that their colleague has a conflict, I would invite them under the informal process to approach their colleague and say, you know, here's what I think, and you might want to reach out to the Integrity Commissioner. The member may also say, I'm going to give a call to the Integrity Commissioner because in my education and outreach capacity, I could then take a look at the situation and reach out to the member and say, listen, it's my understanding, clarify what I may not understand, but if what I have received as information is correct, there might be an issue here. So informal resolution, formal complaint, but you are correct. A member of council, if members of the community say, Chair Hazelton, I think that person has a conflict, they should not be there, they should not be talking about it. There's nothing you can do except file a complaint.
Thank you very much. And I know we have gone way over time here, but I know everyone appreciates your attendance and your comments and guidance. And so with no other hands being up, I will thank you very, very much for this deputation and your sharing of this material with us.
Thank you very much, Chair Hazelton and all members. And for those of the public who were listening, I am available anytime for phone calls or emails about clarification on this presentation. Thank you and have a good day.
Thank you. Beth, your hand is still up, just so you know. Okay, moving on in the agenda, we have the next step is adoption of minutes, and could I have a mover and a seconder for, we have a mover, David Clark, and a seconder, Brian Bocek, that the Township of Georgian Bay Planning Advisory Committee approves the minutes of April 5, 2004 as circulated. All in favor, show of hands, please. And that is carried. Next, we don't have an open forum and we can move into new business. So one of the things that I'd like to do just to introduce the new business is there is, I would say this predominantly impacts the Georgian Bay waters. And so what we have done here is some of the members from the Bay have shared a bunch of pictures, which we have in turn shared with everyone to give everyone an understanding of some of the issues on Georgian Bay with the huge swings in water levels that occur on a periodic basis. So they're guaranteed to reoccur. We just don't know the timeline. So right now, our water levels are going down. 2020 was the absolute highest level. The end of 2011, 2012 was the absolute lowest levels. And these waters fluctuate. And the impacts of that are that there are challenges to waterways, there are challenges to accessing lots. And the purpose of these next two items here was to look at it from a building and development perspective through planning. In other words, if we think today that, as we understand today, we have a building department that has rules of what we are allowed to do, and we have bylaws that control other characteristics of building and development, setbacks and a variety of other things. And so if we were to go and look at our zoning bylaw, and if I wanted to build something on my property, and if I complied with everything in the zoning bylaw, then the planning department would approve my application and hand it over to the building department. One of the things that makes our township quite unique, as I say, is this huge fluctuation in water levels, which on one day means you can actually get to a property and the next day you can't. Of course, that's going to be several years difference. And so the thinking here and where these topics came from before is that from a planning standpoint, just like we have, and Deb provided a very interesting definition. We were talking about accessible waterway or something like that. And she provided the definition. In there it said vessel, but nowhere is vessel defined. And so when we think about a waterfront lot, one has to ask the question to kind of stimulate discussion. Is a waterfront lot always a waterfront lot, or should we have some other definitional parameters around it? Because as we know, you can't develop a property if you can't get a barge there. You can't service a property if you can't get a septic pump out barge there. You can't protect the people that are on the property if you can't get fire and EMS to that property. And so the definition of a waterfront lot, not from a generic theoretical perspective, but from a planning, implementation, zoning bylaw perspective, may need some other words and phrases, just like navigable waterway needs to have the word vessel more fully defined. And so we've got two items here that we can weigh in on that allow us to kind of go down that path where we can give our planning department more context so that as we create a new OP and a new zoning bylaw, they are able to reflect in there things that may be as of right and versus things that may need to go to committee of adjustment, where, you know, we can't pre-plan everything with simple words. We're not a simple township, but we would want to have some basic characteristics in place so that we can ensure that the safety and ability to access the properties or go down a navigable waterway is reflective of our township and the challenges we have in the township. So I'll pause there, and our first hand is Armin.
Thank you, Chair Hazelton. Based on the new information provided by Commissioner Craig, I feel I must resign from the Planning Advisory Committee immediately. I've enjoyed working with all of you over the last couple of decades, and we'll miss our interaction. So good luck going forward.
Thank you for that. So moving on to waterfront lots. Brian, you're first up.
Yeah, thank you. And through you, Chair. Well, I think this is a topic that is worthy of discussion. I think we also need to understand that the methods of development of island properties has changed over the years. I've certainly been on Georgian Bay in the capacity of developing properties over the years, decades. And no matter of what the water swing is, the rush up or roll up, always seems to be a way to access the properties. If there's human inhabitants on the property, obviously they got there somehow, and which means a fireboat or whatever could get there as well too. Over the course of the years, we've seen development of properties using helicopters to bring lifts of lumber in and drop them on the island so that you don't need a barge. So I think this is a topic that needs a lot of scrutiny. It needs a lot of work done on it, and because to come up with a policy that gets entered into an official plan has to be one that is very well thought out, because it affects a lot of people and a lot of businesses. And I think this is something that we need some expert advice on. Unfortunately, one of our expert advisors has left the committee. But I think we really need to dive deep into this and not make any harsh or rash decisions. Thank you.
Thank you. Beth?
Through you, Mr. Chair, sorry. Just in terms of that comment from Member Bocek, our waterways for water access only lots are our public roads. And it is a standard requirement for consent applications, plans of subdivision, site plans, that you have access on a public right of way. And the waterways serve as our public roadway. I don't see development happening in the GTA at all where you only have access from the air from a helicopter. So this is something fundamentally in the roots of the Planning Act, that you have to have frontage on a public right of way. It happens that water access only lots do not. So as I say, the waterway is our public right of way. It is Crown land. There may be situations where you might have to bring things in, like transformers come by helicopters, but buildings are not constructed through material that comes from a helicopter drop-off. That's just my comment on that particular aspect of it. And I was hoping, Chair Hazelton did share some photos that I had shared with him in terms of what the fluctuations are. And they are significant. We have about a 6-foot fluctuation between a low and a high in a strong west wind, and a strong west wind in a high water level year. You can see water levels come up considerably. And I think, Chair Hazelton, it might be worthwhile. Could you pull some of those pictures up while we're just talking about this today? I mean, I've sent some pictures of the Honey Harbor Boat Club, which was in, I believe one of them was 2012 in a low water level year. I sent another one in 2008. And then I sent a picture of a storm surge in the winter of 2020, which was a high water level year, where the waters overtopped the shore wall that was in that picture that you can see from the 2012 picture. So it is a substantial fluctuation. And we also have issues of wave run-up. And I know that the last version of the official plan did try to address wave run-up somewhat as it relates to some of the outer properties, because we can get Ian can speak to it. His property is exposed to the open bay, but we can get substantial swells from Georgian Bay based on the fetch. And then on top of that, there is the surge. So there's high water level, there's the fetch and the wave action, but there's also the surge, which is the bathtub slosh as it goes from one side to the other. And it either brings it in and there's no place to go, and the water level just goes up and up, and then it will fall back, and the other side of Georgian Bay gets the water level. But this photo in here is 2020, and as I say, the water overtopped the shore wall at the marina. They had to raise the paved area within the marina as a result. And if we can go back to another one in 2012, that is Village Marina, flooded in that same storm. You'll see there's some parked cars that are in water because of that storm surge. And this is in winter. In winter, our water levels are the lowest. It's the lowest part of the year. There's another one of just that is the same shore wall. You can see the line from the end of the dock going to the left. That is a shore wall that you'll see in a subsequent photo. If we can move on there. So there we are. That's 2018. Sorry, I can't see it. Sorry. Anyways, there's a couple of water level pictures there. My faces were in the way of the date, but the low water is 2012. And you can see, so And that's another one, just at various times. So I think it's helpful to see some of these photos just to know what we're dealing with in terms of fluctuation. That impacts, for instance, installation of septics. And I know we're not on that today, but it is a concern as it relates to septic installation. That's the restaurant in Midland flooded. Because in Midland Bay, when the wind is in a certain direction, there's no place to go. The water has to build up at the end of the bay. This particular, let's go back to the graph, and I think that's this is a particular example done for an application a number of years ago where access to a block was through the channel, which is at the top of the of this illustration. And when the applicant applied, in this case, it was to lift a hold, the water level looked as it did at the top of that picture in the lighter blue. What we were trying to demonstrate with this particular picture is that in a low water level year, there was no access to this building lot. And the lower level, which shows the channel substantially narrowing in width and reducing in depth to 1 foot 11 in 1984, the neighbors had said they walked across that channel with water up to their knees. And this is just the corresponding hydrographs. And I think the importance is that we need to be able to get access to all properties, as Chair Hazelton alluded, with an appropriate sized watercraft, a construction watercraft, so that you can get in and build the cottage, build the septic. And also in a low water level year, you know that you can get that barge in, and there's a barge picture I sent around that shows what the equipment is you need to pump out a septic. And to Councillor Bocek's remarks earlier, you can't pump out a septic system from an aerial situation. So here are some of the barges, large to small, with an indication of what their dry load depth is and fully loaded. And so if you see even in the small barge, fully loaded draft is, I have to move this picture, sorry. So the small barge, draft of 10 inches, empty, 1 foot 6 to 2 feet, fully loaded. And you want clearance from the bottom, even with a small barge, to get in a low water level year. And that goes up to a large barge. And these are all photos that I obtained and got the draft information from White Construction. The large barge would be 1 foot empty draft, but if it's fully loaded with your material going into a site, it's 6 feet. But most operators would say, I want at least a couple of feet clearance to make sure that I'm not going to end up on the bottom of the bay. So the bottom picture, as you see, that's the septic truck that needs to come in and pump out septics. It's important that they have access in the low water level year. I'll go back to just the hydrographs, and it's just good information to look at. It gives you the highs, it gives you the lows. You can get daily highs and lows, annual highs and lows. But one thing I will point out is those measurements that are taken, that are on the hydrographs that are published on the website, are taken out in the middle of Midland Bay. They are not stations that are set up on the eastern shorelines of Georgian Bay. So you're getting a median, if you will, by that graph information. You're not seeing the full effect of what the highs and lows are on the coastal shoreline of Georgian Bay. So I just wanted to point that out, but I just thought these were good illustrations. Thank you.
So Beth, just further on that,
Mhm.
you talked about uprush and some other terms. And so when we look at the water levels as recorded over in the Midland Bay, that doesn't necessarily reflect, is that your comment? It doesn't necessarily reflect the water levels on the inner bays of Georgian Bay?
Absolutely not, because the bathtub, the slosh, as you see, the median is not getting the effects. So you're getting the extremely highs. You're not catching on this graph, and you're not catching the extreme lows. And I don't know whether we can somehow get monitors on the shoreline, but we've all seen the impacts on a strong west wind. there's a strong current and almost a falls that goes into Honey Harbor Channel when you get that water rushing in and the water rushing out. The navigation buoys get moved by the force of the water on a storm event. I came up last Friday and the green buoy was right in the middle of the channel after a big storm. These aren't my photos, but it certainly shows the difference in appearance between a wetland and a low water level year and a high water level year. Yeah, the right side looks prestige and somebody might actually want to build there. I know Ian will probably want to speak to this one, but these are photos of a property in Cognachine. It was an application to lift a H2 hold a number of years ago. And Councillor Hazelton, maybe you can illustrate where the lot was.
Point of order, Chair.
Yeah.
Do we have a time limit on how long each member is allowed to delegate?
I will refer this to Ian Davis then, because he's made a submission on this.
Actually, we have David Clark up next. So if we could go to David and then come back to Ian and then Brian.
Through the chair, my question is just very quick. In relation to the inland waterfront properties, I've noticed since living up here that, for example, the beaver dams really seem to change the water levels on some of these areas. In fact, recently, probably about a month and a half ago, one of those collapsed and it washed out the entire roadway on between Dwight and Dorset, their main feeders. Is there something that would allow homeowners or lot owners to police that, or do they have to go through the municipality and or the province to adjust that, because that may affect their access and or their how they're going to build out their waterfront section?
Are you referring to managed water levels?
Yes, or your situation is fine the one year and then you've got a major beaver dam over the winter, and now all of a sudden you're down 3 feet, and I think you can even see it going up from Port Severn north. On the right-hand side of the road, there's one wetland that's significantly down and dry, and then others are flooded, and you get into the Wata First Nation, and you can see considerable flooding there. So I don't know if it's all due to that, but I've noted a number of them, and I just had a quick question about that. I don't know if it's something that is manageable if you have one of those lots or not.
Personally, I don't know. Is there anybody else that has any insight into that? Or we'll come back to that. We'll table that as a good question for follow-up. Before we go to Brian, Ian, did you, hold on. Sydney, you wanted to say something.
Yes,
Oh,
the chair.
Yes.
Yeah, we're out of time. We only have 3 minutes left of this meeting, so I suggest adding these items to the next Planning Advisory Committee agenda, just so we can have like a fulsome discussion on these items. Obviously, the IC training took up the majority of our time here. I just don't want to have to cut you guys off mid-discussion, so I think we got a rough idea of the topics, and I think maybe next meeting that you can narrow down recommendations and get into more of a discussion regarding that. So that's all I had to say. Thank you.
I've been told. I'm learning to listen. Okay, Brian, did you have something quick, or did you?
It was just an answer to my point of order through you, Chair, at the amount of time that the members are allowed to speak, because we've got ourselves in a predicament here where this meeting has a hard stop at noon and the meeting was taken over by a member who spoke for a long time. So my question remains as a point of order: how much time does each member have to speak?
I don't have an answer to that. I don't know if our clerk has a off the top.
Through the chair, yes, the procedural bylaw does apply to committee meetings as well.
Okay. Point taken. Thank you. We will revisit that. And with that, we are at 11:58. And our clerk has asked us to wrap up the meeting and include these topics for further discussion. I would ask our planning department to perhaps give us some guidance on what additional things on these topics you would like to hear, if you could. Hopefully, the beginnings of the context have been shared, but I'm sure there's a lot more that we could discuss for kind of deeper context. And with that, I would ask for someone to move that we adjourn the meeting. And I have that from Jack Hope, and seconder from Councillor Graziano. And all in favor? Show of hands. And we are adjourned. Thank you very much.
Thank you, everyone.